as a second felony offender. You are currently serving a 20-year sentence for manslaughter. You were sentenced in 2006. You have a parole eligibility date, which was January 3rd, 2021. You don't earn good time, and you have a full term date, January 15, 2024. Is that information correct?
Yes, ma'am.
Okay. Would you answer Mr. Roche's questions, please?
Hey, thank you, Madam Chairman. Morning, Mr. Fuller. How are you?
Good evening, Mr. Roche.
Well, it's still morning.
Well, good morning.
Mr. Fuller, you're currently 42 years of age.
Yes, sir.
And you've been incarcerated for 17 years, 3 months on a 20-year sentence.
Yes, sir.
And basically, you got a sweet deal. You were charged with second-degree murder, and you were convicted of manslaughter. You were billed as an habitual offender, and the judge sentenced you to 20 years. Is that correct?
Yes, sir.
Which is the minimum state sentence for manslaughter?
Yes, sir. The judge stated that if I wasn't a second offender, he'd have gave me a lot less than 20 years.
Okay. But it's still a sweet deal.
Yes, sir.
You are a second felony offender with 12 adult arrests. You had 3 periods of either probation or parole, and all 3 of those periods are negative. You were revoked twice, and you were terminated unsatisfactorily once. Now, if any of this information is incorrect, you let me know. You are a supervision risk because every time you've been on supervision, you have either been revoked or terminated unsatisfactorily. The entire legal community is opposed. The sentencing judge, the DA's office, the sheriff's office, and the chief of police. The victim's family is adamantly opposed to your early release, even though the victim's mother, who wrote a very beautiful letter saying that she forgave you, but she's still unopposed to your release. You have a low risk assessment score. You've served at least 85% of your sentence. So let's start with your programs. Tell me the good time programs that you've completed.
Well, I couldn't earn a good time, but I done took every program that we had to offer. I started with, I was a facilitator over the Hawks program. I took the anger management classes, the NA classes, Nurturing Father, Malachi Dads. I got my GED. I done took my college courses in the Ashland University. The list goes on and on. I took the truck driving class. I signed up for the welding class. I have an excellent conduct status. And when it come down to my offender class, I really supposed to be a first offender, but my first charge, I ended up taking a charge because I got incarcerated bad. Well, I was 4 houses down from where the police came and did some type of little bust, and I ended up getting caught up in it when I was going to parole.
Sir, if you would answer my questions.
Oh, sir.
If you would answer my questions, I would appreciate it.
Oh, yes, sir.
So you've answered my question. Next question. Tell me about your disciplinary record.
The last write-up I remember having was in 2016.
And what was that for?
A fight.
A fight or an aggravated fight?
Well, it was just a regular fight. I never had an aggravated fight, but
So it was in number 10.
Yes, sir. It wasn't none of my fault. I was just.
Okay, now tell me how many total disciplinary write-ups do you have in 17 years?
I don't know. I'd probably say it's probably under 20 or somewhere around there.
So it's more like 20 plus.
I don't know. Like I said, I haven't had one since I've been here, and
Okay.
the last one I remember was 2016.
Staff,
Yes, sir.
do you have his disciplinary record with you?
I do, sir.
I do not.
Yes, sir. I do have it.
Okay.
The only disciplinary I'm showing here was from October 20th of 2020.
All right.
As for intoxication.
So we talking about October 2020,
Yes, sir.
and he was found guilty. Am I right, sir?
Yeah, what I'm reading here is showing 10 days suspended, 10/31 of 2020.
Okay. Now, Mr. Funk,
Sir.
you know it's a criminal offense to, I'm going to say the word, to lie to a member of the parole committee during an official hearing of the State Louisiana Committee on Parole. I just asked you a question, and you said your last disciplinary write-up was in 2016.
Sir, that was
Sir, I'm talking.
Yes, sir.
And your last disciplinary write-up was in October of 2020, which was less than 12 months ago. So I'm going to tell you the policy of the Committee on Parole. When it sees an offender for a parole hearing, it likes to see that offender right up free for at least 12 months. You do not meet that standard this morning because you had a disciplinary write-up in October of 2020. For that and many other reasons that I will mention at the time I vote, I will probably deny your request because of that disciplinary action. Madam Chairman?
Thank you, Mr. Roche. Mr. Wise?
I don't have any questions this time.
I don't have any questions. We'd like to hear from Siobhan Glover.
Yes, hi, good morning.
You have to unmute your microphone. There you go. Good morning.
Hi. I'd like to first start off by saying good morning. And I want to give honors to God and say thank Him for giving us this opportunity to be able to face this young man. I'm here on behalf of my big brother, DeAndre. I waited patiently 17 years to be able to see your face. Now I had the opportunity.
Ms. Siobhan, you need to speak to the board, not to Mr. Fuller. You speak to
I'm sorry. Okay. I waited 17 years to be able to address this situation. I would like to first say that I would forgive Avionest for what he done, for he not know what he's done. You took the life of a very talented young man. He was a family man, a father, and we don't have many of them. He did it all. He was my Miss Doubtfire. He knew that if he didn't do it, it didn't get done for his kid. My brother was very sensitive. He missed my birthday on December 17, 2003, something he never done. He called me crying so hard, I laughed, like, bro, it's just my birthday. But to him, it was so much, it meant the world to him. The fact that my dad had died in my arms 10 months prior, and you killed my brother 11 months later. The day my dad died, he told me I still had a dad left. So when he missed my birthday, he felt like he failed me. I love my brother. You took something from me he took something from me that can never be replaced. My brother raised me. It was just the two of us for a long time. Wherever he went, I went. I moved to Louisiana with my brother on 3 different occasions. We raised each other. Once I got grown, I became his big sister, giving my big brother advice. We inspired each other. Ever since I got called about Avanti is trying to get an early release, I've been having anxiety attacks, something I never experienced. He scorned me for life. You can never apologize to my brother, so why should I accept it? You are a child. Avanti is a child of Satan. There is no place for him in this earth. It's just something you do not do, and murder is one. You are not God, so you cannot take a life away. You stole my brother's life. Avanti stole my brother's life. He was happy. He had moved one of his eldest daughters there with him, who was pregnant. He delivered his granddaughter, Honesty. He was so excited. My niece came home in December. January, her father was murdered. Ever since, my
Can
niece
you
been
wrap it up
blaming
for
her.
us, Ms. Glover? We're running out of time.
I'm sorry, but this time, well, artist, my brother was an artist. He was a producer, which was behind a lot of talented artists. My brother was murdered 6 days after my mama's 50th birthday bash. He was supposed to come, but he said he had his album release party. And he was trying to get me to Louisiana. Had I had a cane on God-given earth, that young man wouldn't have been able to get as close to my brother because I would have protected him. And my mother would have been burying 2 kids instead of 1. Vatius tried to reach out to my mom to ask her to write a letter, but he can get out early. And I felt that's something that was wrong, and he showed no remorse. So, with that
All right,
being
thank you,
said,
Ms. Glover.
I don't know what
Go
this
ahead.
one.
Wrap it up.
My brother was
Wrap it up
supposed
so we can hear from Kevin. We're running out of time.
to run from Kansas City on
well, I have a lot to say, but at this point,
I
I'm going to
understand,
go
and
ahead
we
and let
do
my
have
little
your
brother
letter.
finish.
Yeah,
I
we
could never
do
send
know
my
that we
letter.
have your
My
letter
mom.
in.
Yeah,
No, we have a letter from you in the record.
show them.
Go ahead, Mr. Kevin.
Okay, thank you.
Hello, hi. Hello.
Go ahead. Yes, go ahead.
Hi, good morning. My name is Kevin Glover. I'm DeAndre's baby brother, and I'm speaking on behalf of him, my sister, my mom, my brothers, all of his kids, just the hurt and years that we have to go through still, like as if it was yesterday. I just I don't feel that it's right for him to be released early, and in no any situation, it's just not right, and like I see that we're limited to speaking, how we really feel, which is, it's kind of it's just hard, it's a lot to say,
Yeah.
I couldn't forgive him, just based on the fact of, doing what was done. It's hard, it's just hard, man, it's hard, just don't feel that it's right and okay, for him to be released early.
Well, thank you, Mr. Glover and Ms. Glover. We do appreciate you taking the time to share with us this morning. Let me ask Mr. Fuller, is there a statement you'd like to make?
Am I going to get a chance to say something?
Mr. Fuller?
Yeah.
Yeah, I'm asking you, is there something you'd like to say?
Yes, ma'am. Because
Go ahead.
DeAndre,
Address the board, not you direct your comments to us. No, you direct your comments to the board, okay?
okay.
Go
Well,
ahead.
I met DeAndre when I was 10 years old. He was approximately like 9 years older than me. You know what I'm saying? Whatever happened between me and Andre, it wasn't none of my fault. You know what I'm saying? I was defending myself. I wasn't the aggressor in this situation. You know what I'm saying? She trying to make it seem like this man was a saint. You know, I had a family. He took me from my kids. My youngest son is
Yeah,
older.
you're not helping yourself right now.
I understand, but
You're not helping yourself, Mr.
my
Fuller.
oldest son is older than I
We're-
was. I can't,
What you need to be telling us is why should we consider you for parole, not about what happened.
because I'm trying to go out here and
We
be-
know what happened. We got it in the record.
Oh yes, ma'am. Well, I'm trying to go out here and become a part of my family life. I've been gone 17, 18 years. My youngest brother, older than I was when I came to jail. My nephews and nieces, I don't even know my own family. I've been in jail so long. You know, I done been up in here trying to keep it best, right now, I was sentenced to 20 years in DOC. I'm in a parish prison, 18,000 that's up in there. It's rough,
Yep.
you know, and the living
Yep.
conditions hard. You know, it's a lot going on. I'm trying to go out here and start my life. I'm 42 years old. What happened then, I was 25 years old. You know what I'm saying? In them little couple of months or years that I got before I could go home, I could be building putting my life back on track. You know, if anything, I had an old lady. I had a house. I was paying bills. I had a job. You know what I'm saying?
Okay. All right. All right. I do know what you're saying. We're going to go ahead and
This brother was a
vote.
saint.
Mr. Roche, are you prepared to vote? Mr. Fuller, we're going to be voting. Mr. Roche?
Yes, Madam Chairman, I'm prepared to vote.
He put on a good show.
Sir, the voting process has started. You should listen and not speak.
Yes, sir.
Mr. Fuller, based on a disciplinary write-up in October of 2020, a number 14 for intoxication, opposition from the entire legal community, the family of the victim is adamantly opposed, and based on a very poor supervision history, my vote is to deny your request.
Thank you, Mr. Roche. Mr. Wise?
At this time, I'm gonna vote to deny. You had a DB report. I mean, your strong victims opposition to this release. And let me tell you something. You know, we can blame it on this and blame it on that. But if there's ever friction between two people, I always try to go the other way or he go the other way. But that didn't happen this time. And today my vote is the same as Mr. Roche. Thank you.
Mr. Fuller, I do concur with my colleagues based on the opposition that's been expressed today, that which we have in the record from law enforcement, as well as the intoxication in October of 2020. My vote today is to deny your parole. So today, sir, your parole's been denied. Thanks to the Glovers for participating today. I think that concludes our business at Richland. So we will adjourn. It is 10:36 p.m.
how do we unpack that? You know, I think first off, I do want to address how Miss Renatza just tells the victims who's clearly just the pain is still raw. She starts off by saying that I have waited 17 and a half years to see his face. And she's just, the emotion is so raw as if it had happened yesterday. And for Miss Renatza to just tell her to wrap it up and then to cut her off. If you see my face, I bumped my head swimming the other day. So hopefully it'll go away. But, and I just don't understand why she does that. You know, you can give a couple extra minutes, just have some empathy, some sense of like it's just the right thing to do. I don't understand it. And you know, if you want to counter, at least she was being appropriately trifle with, or trifle, is that the right word? You know, she wasn't treating him very well either. But I mean, he was talking back while she was speaking. He was snapping. He was muttering things. He was being incredibly disrespectful. To think that he's going to be out in just a few years, and you can only wonder, you know, how they're going to get around being in the same area. Also, what, you know, I read this, and we'll go over it. There's actually quite a lot of information in this. Thank you, Claire, for recommending this hearing, and Richard for the info. He took this to a bench trial, so there's no jury. So, you know, he's charged with second degree, and the judge gives him manslaughter, gives him the maximum 20-year sentence, and then is opposed to him getting released 2.5 years early. And it's just, it's interesting. It's going through the facts of the case. I do wonder how the judge decided to. This wasn't a jury. We see a lot of bench trials in Louisiana, and that's because up until I think 2 years ago, Louisiana was one of the only 2 states in the U.S. that did not require unanimous jury. You could have a 10-2 jury verdict and still get life in prison. So, you know, it's because of that, I think we see more of these type of bench trials. But I don't know. It's like the judge, and I mean, I guess that's what you would say a fair judge is. But by saying, no, you're going to serve your full 20, I would have given you more time, or I gave you more time because you're a repeat felon. But I don't. Anyway, so here it is. It says that the victim, they were friends at one time, as they said. The victim's wife recounted that the defendant had been a guest at her home in the past. At some point, the relationship soured as Welch became upset that the defendant, for reasons not entirely clear in the record, some related to the discord to a dispute concerning drugs, while others related the matter to involving a dispute involving a woman. Although the exact matter of dispute was unknown, Fuller was convinced that Welch was intent on killing him. The blood between the men continued. At some time prior to the shooting, Welch made known his intentions to deal with Fuller for snitching. After the declaration, Welch and his wife pulled weapons. So this is the victim and his wife pulled weapons on him. The evening before the fatal shooting took place, witnesses and Fuller alleged that Welch again pulled a weapon and threatened to shoot him, but was deterred from the action. So they have pulled weapons on him twice now. The next day, on January 14th, 2004, Fuller saw Welch walking a dog in the neighborhood where the defendant's mother lived. The victim's mother-in-law was also a resident of the area. After seeing Welch in the neighborhood, Fuller, armed with an AK-47 assault-style weapon, drove to Welch's mother-in-law's home and confronted him about the previous threats. So this is the day after him and his wife pulled weapons on him twice. He then saw him in his neighborhood and he approached him with the AK-47. The men talked briefly before Fuller opened fire on Welch. As Welch attempted to flee, Fuller chased him while firing a barrage of bullets. Welch eventually fell, and Fuller stood over him, shooting into his body. 22 shell casings were recovered from the scene and Welch had at least 14 gunshot wounds. At least one was inflicted to the back of his head. Fuller was arrested on the shooting and charged with second degree. The defendant elected to be tried by a judge and was found guilty of manslaughter. The trial judge then sentenced him to 20 years. And all I have to say is, how does a trial judge find that to be manslaughter? Can someone explain that to me? Can someone make that make sense? Maybe I don't understand. Like, I get both parties were not, if they had pulled weapons on him twice and threatened to end his life, but as soon as you chase someone down with a rifle, stand over his body and empty the magazine into him, that's not manslaughter anymore. And a judge said it was. This is long. This is a very long report where they go through a lot of different information. But I did go through the information. I read through it all. And I'll share different snippets. But they did not find any weapon on him. So when he was chased down and shot in the street, he didn't have a weapon on him. On cross-examination, Ray testified the defendant maintained he shot the victim in self-defense and saw the victim with the gun, and that he saw the victim with the gun. He also mentioned that Fuller indicated he went to walk to Welch to determine why he was trying to kill him. Ray also testified he learned just prior to the trial that Harvest White provided the DA's office with a letter indicating that a gun had been taken from the scene, but Ray had not investigated this claim prior to the trial. So there's some statement that there was a gun, but they had taken it. The crime scene investigation and processed the crime scene evidence. On the second day of the trial, the state and the defendant entered a stipulation regarding the crime lab export. According to the stipulation, the casings recovered and examined were consistent with being fired from the same weapon. Then the victim's wife testified on behalf of the state. At the time of the trial, the witness was incarcerated while she was incarcerated. According to Miss Welch, she and the victim were waiting outside her mother's home just prior to the shooting. As they waited outside, Fuller pulled up in his truck and began talking. He then got out of the vehicle, ran up the driveway, and started shooting an AK-47. She further testified that when Fuller pulled up, the victim told her to run, which she did. As she ran, Miss Welch saw Fuller chasing her husband, so she hollered, telling him not to shoot. Miss Welch heard the defendant say, I'm not going to read that, and this is going to be your last time you breathe. Fuller chased the victim while shooting him in the driveway. Miss Welch indicated the defendant was shooting the gun during the entirety of the chase and fired approximately 14 or 15 shots. According to Miss Welch, after the victim fell between the two cars parked in the driveway, the defendant stood over the victim and fired more shots at him. While the victim did not have a weapon at the time of the shooting, Miss Welch indicated that she had that day. After her husband was shot, she ran into her mother's house and asked to call the police. After doing so, Miss Welch Hi. Welch went back outside to her husband and picked up his head and found him dead. You know, it really blows my mind, all this stuff. It's like, it's like, someone, because really it just seems like a lot of ego in place. It's like, if someone's threatening your life like that, what good is it going to do to go and confront them in the street anyways, and in broad daylight do that, so that you would then, he's lucky he's not spending the rest of his life in prison. It's like, that's the mentality of the person who's sitting here. You can see he's learned nothing. He doesn't believe he did anything wrong, and he thinks he's wrong, and he's going to get out of prison. These are the kind of cases, Sally, that you hear about, where someone who took a man's life gets out and takes another man's life. It's scary, and he will be out soon. I don't really understand how. Now, I'll drop the link if you want to read the entire thing. There's like I said, it's quite long, but I just don't really understand how. So here they say, I disagree with conflicting language that the portion of the majority opinion where it finds the offense was committed in sudden passion and heat of blood immediately caused by provocation sufficient to deprive an average person of self-control and cool reflection, and then in addressing self-defense finds that there was no provocation and the defendant simply carried out a preemptive strike. A preemptive strike is planned intentional action and the antithesis of sudden passion, heat of blood caused by immediate provocation. The legislators provide a list of lesser and responsible verdicts. Our court has recognized that a defendant has statutory right for a jury, or in this case, judge, to convict a defendant of the lesser offenses through the evidence clearly and overwhelming support a conviction as charged. This is called nullification. I note that the judge did not refer to sudden passion or heat of blood in rendering his verdict. He did not find the victim was a man of ill repute. He obviously considered that both the victim and the defendant were members of Rolling 60s gang, and that one was destined to kill the other. All this court needed to say is that the evidence clearly supports the charge of second degree, and that manslaughter is a legislative responsive verdict to the charge. It's interesting to read that they're destined to kill one another. But they affirm that it was manslaughter. It is interesting. I don't know enough about how that works. You tell me. I thought it was interesting how Mr. Roche said, "Do you know that it is a crime to lie to the parole board?" And we've heard them say that, I think, once or twice, 2 other times. And I wish that they would enforce that. And maybe some DA does somewhere and we just don't know about it. But especially there are some cases where it's very clear that they're lying to the parole board. And I really wish that they would, that it would be enforced in some way. But with that, I'll let you go.